Hello everyone. Good evening. Can we all hear me?
Yes, we can.
Yes, we can.
So sorry. That I'm having a little challenge again with my Zoom platform, but we will be starting right about now. I want to say welcome to everyone that has joined in for the call already. So just give me a minute. Let me get everything back on track so that we can start immediately. Sorry, just a minute.
Dennis, do you need help?
Sorry, did someone say something?
Yes, I said, do you need help?
Yes, I need help so far. Please, can you just help at least get the mentees to start their presentation? Welcome all the mentors and get the mentees to start their presentation. Sorry, my network has been frustrating and still it's still logging me out and in. So please, can you just help me start?
Okay, so good evening, everybody, and welcome to today's class. I can see some of our mentors on the call already. So, Mr. Nachan, good evening. Mr. Isaac, good evening. And I welcome our mentees too on board. So please, if you have maybe your group mates and the presenters who are not yet on the call, kindly reach out to them to come on board. So once again, good evening, everybody. So do we have group one presenters on the call?
Yes, ma'am.
Can All right. So I think you'll be starting your presentation first. Um, do you have your slides with you? So possibly you could project it, you could share your screen and present. Thank you.
All right, Sophie, thank you so much for helping me start. I'm back on the call. Firstly, I want to sincerely apologize to everyone for my network. I've just encountered or experienced some issues, but I am fully back on track. All right, so I really want to welcome all of us to this session. I want to
Yes,
welcome
sir.
all of us to the session. We are going to be commencing by introducing our mentors like we normally do. So we are currently in week 3 of the Gypsy Mentorship and Internship Program, and today we'll be discussing arbitration and the career opportunities in arbitration. So in today's class, we'll be having a few of our mentors. That is before we get back to presentation, we'll be having a few of our mentors in the call on the call. In today's class, we'll be having Mr. Nyacham. Sorry. Okay. The arrangement is not in order, but we'll be having firstly Mr. Nyacham in today's class, and then we'll also be having
It's not there.
Miss. Can we hear me? Who is speaking on the other side? All right. So in next we'll be having Mrs. Nispa Pra Awosun. In the session we'll also be having okay, trying to find her flyer, Mrs. Deborah Maida Megari, and also like we already have on call, Mr. Isaac. Thank you so much, sir, for joining. We'll be having Jennifer Anehe, and then lastly, we'll be having Mr. Archie Dabara. So those will be our mentors for today. All right, okay. I can see we already have our presenters sharing their screen. Group one, I may assume that you are the one already sharing. So please, you can go ahead and start your presentation.
All right, good evening, everyone. My name is Ayeni Boluwatife Favor, and I am the presenter for Group 1. And the topics before us is arbitration and career opportunities in arbitration. There are subheads that I'm going to be talking about. The first one is about the career opportunities in arbitration. I don't know if you can hear me.
Yes, we can hear you.
Okay, so I'm going to be talking about the career opportunities in arbitration, arbitrability of disputes under arbitration, and can arbitration be used to resolve any kind of disputes. I'm also going to be
Sorry,
talking about.
sorry, Boluwatife, sorry for cutting in. We can't see your screen anymore.
Mhm. So can you help us project it?
Someone is already doing that.
Okay.
Thank you very much, Favor. Yeah, so Bolu, we
Okay, can
have,
you see it now?
yeah, we can see the screen now. Please, you can go ahead and start.
Okay. So as I said before, that there are subheads under this arbitration and career opportunities that I'll be talking about today. The first one I'll be talking about are the career opportunities in arbitration, arbitrability of disputes under arbitration, and can any arbitration be resolved? And I'm going to also be talking about the arbitration clauses and its significance, also revocation and otherwise the arbitration clauses and agreements. Also, I'm going to be talking about arbitral awards and its importance competence. So in the earlier weeks, we're talking about ADRO and the types of ADRO that we have. We mentioned about negotiation, mediation, conciliation, and arbitration. So I'm going to just re-emphasize on our major topic, which is arbitration. So from this slide, it says that arbitration is one of the widely most widely used mechanisms. I don't know if you can see it. Okay. Arbitration is one of the most widely used mechanisms of ADR, in which disputing parties agree to submit their disputes to a neutral third party, known as the arbitrator, who hears and render a binding decision known as the arbitral award. So what arbitration is just talking about is that it's widely used as a mechanism of ADR, that is alternative dispute resolution, that is settling a dispute outside the court premises, outside the traditional court that we all know. And it is always organized by a neutral third party, that means someone that is of a clear mind, that is not out of favor or fear of any of the parties that have brought dispute before him. And he also render a binding decision, which is known as an arbitral award. So whatever decision resolution that an arbitrator is giving is known as an arbitral award. And one thing that is important about arbitration is that it mimics the court proceedings, but with a greater speed, with flexibility and informality. It's not as strict as litigation. So I will continue. So one of the advantage of arbitration is that the parties are able to choose the arbitrators. They determine the procedural rules and maintain confidentiality, which is often not possible in an ordinary court proceedings. As I said before, it is mostly of a greater speed, and it is flexible. It's not rigid, or you already know how it's going to be. But this one is like they are bringing it before a neutral person, and it's the person that will is the parties that will determine the procedural rules, and which is not like a court
Sorry,
proceeding. So is the arbitrator.
sorry, can you hear me? Sorry to cut you. Sorry
Yeah.
to cut you in again. I think the slides we are using, we are not necessarily following. I think the person sharing is not. I don't know if he's able to follow you because I'm seeing that it's having issues sharing. So please, can you kindly stop sharing and I will share on your behalf. Mr. Favor, you can stop
Oh,
sharing and
okay.
I'll share on her behalf. So I have like a much smoother transition.
Okay, sir.
All right, so give me 1 minute. Let me quickly do that. So when you want to move to the next slide, just kindly let me know.
Okay.
All right, so please you can go ahead.
Okay. So I'm in the third paragraph that says that the arbitrators hear evidence and arguments and give a decision which is called the arbitral award. And an arbitral award is binding and enforceable like a court judgment. So one thing that differentiates arbitration from negotiation, mediation, and conciliation is that it renders a binding decision that even the court respects the decisions of an of under the arbitration tribunal. So it's one thing that that differentiates it from negotiation, mediation, and conciliation. Please, the next slide. Okay. So arbitration has gained global recognition through international legal frameworks and institutions such as the United Nations Commission on International Trade Law, which developed the UNCITRAL model law, guiding arbitration practice worldwide. In Nigeria, there's an enactment that actually regulates arbitration, which is known as the Arbitration and Mediation Act 2023, which was formerly the Arbitration and Conciliation Act. Now, this act, it provides legal framework governing arbitration proceedings in Nigeria. So this, in a nutshell, what arbitration is just trying to tell us is that it is governed by a neutral third party. It is the parties that assign the arbitrator, it's the party that choose the arbitrator, and this arbitration renders a binding decision known as the arbitral reward, and it mimics the court proceedings. So this is one thing, or these are several dimensions of arbitration. So we'll move to the career opportunities the key features of arbitration. So it is the next slide. Okay, it is private and confidential. Okay, it is private and confidential in procedure. It's flexible and it's chosen by the parties. So parties can choose expert arbitrators as well. The parties has that chances to choose someone that is expert in the dispute they are bringing before the arbitration or the arbitration tribunal. And we also have faster resolution than a court litigation, and the decision is final and binding. So these are features of arbitrations that we ought to know. So going to the first subhead of our topic today is about the various career opportunities in arbitration. So now, arbitration actually offers a wide range of professional opportunities for lawyers and even other professionals involved in dispute resolutions. And I'm going to be talking about the opportunities that we can venture in arbitration, or as many mentees that want to take in arbitration as a life or a livelihood. So these are opportunities that we can see in arbitration. Number one we have is the arbitrator. So an arbitrator is a neutral third party appointed to resolve dispute between parties in arbitration proceeding, just as how we looked at what arbitration is all about. So a person can actually become an arbitrator as a career. We can take it can be an arbitrator as a career profession. So there are responsibility that an arbitrator should possess, or these are the things he should do when he's venturing into this kind of career. So one thing is that he can conduct an arbitration hearing. He evaluates evidence from both parties and the arguments of both parties. He ensures that there is fairness and due process of the law. And he also interprets the applicable laws. As I said before, that it is the Arbitration and Mediation Act that governs arbitration in Nigeria. So he can actually interpret whatever the enactment is saying on the issue or the dispute brought before him. So he also delivers final arbitral awards, which is binding on the parties. So this is what an arbitrator is all about, or this is what his most responsibility is all about. And there are also institutions that appoint arbitrators. We have the Chartered Institute of Arbitrator. I think their headquarters is in London, and they have a branch in Nigeria, which is in Lagos. So anyone that wants to venture to be an arbitrator can work here. We also have the International Chamber of Commerce, which is located in France, and we also have the London International Tribunal Arbitration. So these are institutions that appoint an arbitrator. So we also have the next one, which is the arbitration counsel and advocate. So arbitration counsel and advocate is that person that represents one of the disputing party in an arbitration proceeding. That means that is just like litigation, but it's more like a private dispute, not like it's a public. So you know that many people can hear your issues that is brought before a litigation court or the normal court that we know. But in this kind of role, or in this kind of career, you are like representing one of the disputing party in the arbitration proceedings, and most of the responsibility that can be bestowed upon this kind of individual or this counsel is that he advises clients on dispute resolution strategy. He can draft a statement of claim or a statement of defense. He also presents legal arguments before the arbitral tribunal, and also enforce arbitral award in court where necessary. So we have most individuals or popular arbitrators in Nigeria that we know. We have Funke Adekoya, which is a leading arbitration lawyer and even an international arbitrator. We have the likes of Afe Babalola, who is the owner of Afe Babalola University. He's a respected arbitration practitioner. We also have Bola Ajibola, who is the former justice of the ICJ and is a respected international arbitrator. So these are individuals that venture into arbitration and they are doing well for themselves. So another career opportunity that we have is tribunal secretary. So who is a tribunal secretary? Is a person that assists arbitral tribunal in managing arbitration proceedings, particularly in a complex cases. And this someone who wants to be a tribunal secretary, most times this role is beneficial to young lawyers seeking for early experience in arbitration. And most of the roles that they actually engage in. They organize arbitration documents and submissions. They conduct legal research for tribunals, and they also draft procedural orders. They assist in preparing part of the arbitral award. So this is the key responsibilities of a tribunal secretary. So we also have the next one, which is the arbitral institution staff. So there are lawyers that even works in institutions that administer arbitration proceedings, such as I mentioned before, the International Chamber of Commerce, London Court of International Arbitration. We even have Lagos Court of Arbitration. So most of their key role is that they manage arbitration proceedings, they coordinate between alternative between parties and arbitrators, they develop and implement arbitration rules, and also promote arbitration and ADR mechanisms. So these are key roles that an arbitral institution staff actually engage in. So we also have the next one, which is the arbitration consultants and expert witnesses. Now these are people that are specialized in expertise in a particular field. For instance, we have the engineers, we have in finances or constructions. There are people that are experts in this kind of area. So when there is a dispute that arises in this kind of field, the parties can decide to engage them into arbitration to be able to settle their disputes brought before the tribunal. So their key responsibilities are they provide expert opinions and report on that technical matter. So any technical matter that concerns construction, engineering, or finances, these people they can provide their own opinions on it. So they also explain industry parties to the tribunal, and they also act as a witness, or they testify during arbitration hearing. So this is what arbitration consultants are all about. Then the next one we have is academic researcher. So this one is quite popular because I can remember in my 100 level, that's the first time I heard about ADR or arbitration. So these are individuals that take this as a career, whereby they venture into academics and research institutions, so such as the law lecturers, researchers that are specialized in arbitration of law or ADR. So their key responsibilities in this academic researcher is that they conduct research on arbitration laws and policy. They can even publish books or scholar articles. They can teach arbitration in universities, and they also provide policy recommendations to government and institutions that when necessary. So this is what the academic researcher it's all about. So we also have in-house counsel. I like this one so much because it's kind of direct. So these are people that maybe a large company, they actually arbitrators inside the large companies. They they manage disputes through arbitrations. And one thing about them is that they can draft arbitration clause in commercial contracts. They select arbitrators when necessary and when dispute arises, and they also manage and oversee arbitration proceedings. So the opportunities in these fields can also exist in industries such as the construction, banking, telecommunication, even international trade. They always need an in-house counsel that can arbitrate on their disputes. So last but not the least, we have is the mediator and the AD specialist. So many arbitration practitioners also work in other forms of ADR, such as mediations, and their key responsibility is that they facilitate negotiation between disputing parties. They help parties to reach settlement agreement, and they also reduce time and cost compared to litigation. So this is what these are many careers that you can find in arbitration. So in case you are interested in any of them, we have heard about their responsibilities and how they are relevant in the society. So we are going to be going to the roles of an arbitration generally, like from the first career opportunity I talked about down to the rest, is that they have to be neutral either way. Wherever you are, either you are an academic researcher, in-house counsel, a mediator, these are things you should be able to do as an arbitrator. You should be neutral. You should be a neutral third party when dispute come before your hearing. You can also conduct hearing from both parties, hear from both sides. You evaluate evidence, that means you weight evidence from both parties, and you also interpret the laws and the contract that is brought before your the tribunal, and you also issue binding arbitral awards. So these are roles of an arbitrator, no matter where you decide to um take as a livelihood. These are things you should possess. So the next thing we are going to be talking about is the arbitrability of disputes. Now, arbitrability of disputes is refers to the legal capacity of a dispute to be resolved through arbitration rather than litigation before a court. So this is just when you hear about arbitrability, is it just leads to one thing: the capacity of it to be resolved or not. That is what it is. It's just like in evidence, are the evidence admissible before the court, or they are not admissible before the court. So this is what arbitrability is just talking about, if it has the capacity for hearing. So while arbitration is largely based on agreement of the party, the arbitrability of the subject matter of their dispute is determined by law. Hence, not all disputes can be lawfully referred to an arbitral tribunal. And I think there was a question that was asked at the subhead that says, can arbitration be used to resolve any kind of dispute? So the answer here is, it's not all disputes that can be brought before arbitration. So arbitration or arbitrability is actually classified into two. We have two categories. We have the objective arbitrability and the subjective arbitrability. These two, subjective and objective, is what is determined if the court or the tribunal can hear such a case. Now, when you hear about objective arbitrability, it's just trying to look at the position of the law that guides that jurisdiction. Can it actually admit that dispute brought before the arbitration? Can it hear it? Does it have that capacity? But when we talk about subjective arbitrability, it's just trying to tell us about the capacity of the parties themselves to submit dispute to the arbitration. So there are some things that can limit the capacity of the parties, and the parties. For instance, minor minority. If the parties that brought the dispute, if they are of a minor age, that is already leading to non-admissibility. That means it can't be admitted before the arbitration. So there are other incapacity of parties that can also lead to that dispute not brought before the arbitration. For instance, we also have, if they are of unsound mind, or if it was through fraud or misrepresentation or mistake of the contract, such things will not allow the tribunal to be able to adjudicate on that matter. So on that matter. So arbitrability is generally determined by the law of the jurisdiction where arbitration is conducted, or where enforcement of the arbitral award is sought. Hence, arbitrability is both of domestic laws issues and an international enforcement consideration. So it can either be under our laws or even internationally. Arbitrability is a subject matter that actually determine if that case or dispute can be brought before the tribunal. So it is a very it's something that should be put into consideration in both points of laws, or in both points of views. So we are going to be looking at arbitrability under international law.
Hello, Bolu, can you hear me?
Yes.
So please, can you start rounding up your presentation? Please, we are spending so much time on it, so let's just try as much as possible to get it over with as soon as possible.
Okay, sir. Okay, so in that arbitrability, I'll just go down to Nigeria laws because it's what concerns us. So in arbitrability under Nigeria laws, it's actually governed by the, as I said before, Arbitration and Mediation Act, and we can find it under section 1, 2, and 5 of the Act that talks about and the arbitrability of dispute if it can be held by the tribunal. And under section 55 and 58 of the act, it allows court to refuse enforcement of the subject matter if it does not meet the capacity of the party, or if it's not under the law, or if it even violates public policy. So we also have in Kano State Urban Development Board versus Vance Construction Limited, where the Supreme Court affirmed that parties who freely enter into arbitration agreement should generally be held to their bargain unless the dispute concern are not legal. So it is actually binding because it's a general principle that arbitration decisions are binding. Otherwise, if it is, except it is not legally arbitrable at the first point. So there are disputes that are not under arbitration. For instance, we have um, criminal offenses. So criminal offenses, they are actually state matters, and they are actually prosecuted by the attorney general. So it's not supposed to be under the heads of arbitration. We also have matrimonial causes such as divorce, nullity of marriage, judicial separation, and child custody. All these are matrimonial causes, and they are always under the High Court of exclusive jurisdiction to hear and determine matrimonial causes. And we can see it under Section 2, sub 1 of the Matrimonial Causes Act. We also have tax disputes. These are concerning government revenues and statutory obligations, so they ought not to be under arbitral tribunals. So when we talk about arbitration clause, all you just try to do is that there are clauses that the parties to the dispute are supposed to agree to before they even commence the arbitration itself. So if they agree on it, it is what binds them, like it is what binds them. And under these arbitration clauses, there are some things they will look at. They'll look at the numbers of arbitrators. That is what the parties will agree on. They'll look at the place of the arbitration, the rules governing the arbitration, as well as the language of the proceedings. So in that place, we can see example of a simple arbitration clause. This is like an example of which both of them agree for them to be guided. So we will therefore look at the revocation of arbitration agreement. So revocation just talks about cancellation and maybe withdrawal of the arbitration agreement by the parties themselves. So it is, even if it is binding, but there is an exception in which it can be revoked if the two parties agree for it to be revoked, or if it is by the order of the court for it to be revoked. So it can either be done by revocation by mutual agreements, court intervention in special circumstances, even a waiver through participation in litigation. Let's say, for instance, if during the midst of arbitration, one of the parties decides to waive it by bringing it into litigations, in such way it can be revoked, even in invalid or void arbitration agreement, as well as death of any of the parties or death of the arbitrator itself can actually revoke such arbitration agreement. So um and okay, so when an arbitration clause or agreement is revoked, this is what happened. It means that the arbitration proceedings cannot continue, and any of the arbitration clause in the contract loses its binding force if it has been revoked either by the court or by the parties. Then when we talk about arbitral reward, as we said it before in our beginning part of what arbitration simply means, it's just talking about the decision given by the arbitrator itself. So is that final decision determined by the arbitral tribunal after considering submission of evidence. There must be evidence between the both parties that must be considered, and the arguments presented into the parties. So one thing about arbitral award is that it binds the parties. It is enforceable. That means it is even respected by the court itself, and it is recognized internationally if it has to do with international countries and they want to use arbitration as a way out to resolve their issues. So there are components of arbitral award. These are things that must be there. First of all, is that when you are giving a decision on both parties, it must be written and signed. You must state the reason for the decision. As an arbitrator, you state why you got to that decision for the parties, and you also state the date and the seat of the arbitration, the identification, that means the names and the address of the parties. You also look at the operative course and decision why you were carrying out the arbitration. These are things you will put into the arbitration award. So we have the types of arbitral awards. We have the final awards, interim awards, partial awards, interlocutory awards, and agreed awards. Although this is not part of it, but this is like an enlightenment of the arbitral awards that can be given. But just know that it's all talking about the decision of the arbitrator at the end of the day. So when we look at the types of relief in arbitral awards, so arbitral awards may grant different forms of relief depending on the nature of the dispute. So when one of the parties win the arbitration after the decision has been held, he can actually receive a monetary award that is ordering one of the party to pay damages or compensation to the other party. And also we have declaratory awards that is clarifying a legal right or obligations of the party. We also have injunctive awards that is directing one of the party to reframe or perform a particular act. And we also have cost awards determining a party should bear the cost of arbitration party. So these are relief that can be carried out when giving out an arbitral award in favor of one party against the other. So in conclusion, we just in conclusion, we are just saying that arbitration is like widely used as a mechanism to resolve disputes between parties, and it is efficient and also as a way of being confidential, unlike litigation. And we also say that it is important in international commerce and also offers career opportunities to lawyers and even professionals in a particular field. So I just want to thank everyone because I've come to the end of the presentation. Thank you.
All right. Thank you very much, Ruby, for your presentation. Well done to you and to your team for putting that presentation together. It was quite lengthy, but well done to you for at least putting a summary and putting a tie on it. So well done once again. All right, so we are done with the first presentation. Can we have the presenter for group two? Please let's quickly do that so that we can get to the rest of class. Can we have the presenter for group two?
Good evening, everyone. Can you hear me?
Yes, hello, Mr. Joseph. Yes, we can hear you.
All right, let me share my
Hello,
screen.
Mr. Joseph, we can hear you. All right.
All right, so I'll be sharing my screen. Can we all see it?
Yeah, yes. Is it possible to put your screen on landscape? You can press play and then it's going to rotate so that we can see it very well. Yes.
All right, sir. Okay.
All right,
My name is
please go
Joseph
ahead.
Vitus. All right, thank you, sir. My name is Joseph Vitus, and this week's presenter for Group Two, and I'll be speaking on drafting an arbitral award and its key features, relevance of ADR and arbitration clauses, ethics in arbitration, differences between seat, place, and the rules of arbitration, and challenging an arbitral award, enforceability of arbitral award, and then the conclusion. So without wasting our time, I will go straight to the point. I'll be starting from drafting an arbitral award and its key features. From what is being written here on our slide, an arbitral award is a formal written final decision issued by tribunal to resolve a legal dispute. Similar to a court judgment, it must include identification of the parties, a reasoned analysis of the issues, the final orders or remedies, and the signatures of the arbitrators. So that's what the first slide is basically uh, um, telling us on the drafting on the award of its key features. So I'll be moving to the second slide and we're speaking on the relevance of ADR and arbitration clauses. So an arbitration clause is a contractual provision, or which is a contract providing requirements to dispute to be resolved through arbitration instead of litigation. It is used to ensure speed, confidentiality, the use of expert arbitrators, and the finality and international enforceability of the resulting decision. So on the next slide, I'll be talking on the sample arbitration clause. So this sample arbitration clause, here it outlines a multi-step process for resolving legal disputes. First, you see the first is through the good faith negotiation, and then if that doesn't work, then it can now move to mediation, and then finally the binding arbitration. It specifies the it specifies that arbitration can be used using the arbitral rules of 2021, which guides the Nigerian Institute of Chartered Arbitrators, mediation rules. So here it shows that the seat of arbitration shall be Lagos, Nigeria. The arbitration shall be conducted by sole arbitrator, and the language of arbitration shall be English. So in arbitration, English is the main language, and then the seat of arbitration is Lagos, Nigeria. So I'll be moving to the next slide. The ethics in arbitration. So ethics in arbitration ensures fair process through arbitrator impartiality and transparency regarding conflicts and strict confidentiality. It requires that all parties receive equal treatment while the arbitrators maintain high standards of competence, integrity, and honesty. So, what I've just said now just covers everything that has been listed from number 1 to 6. So, I'm moving to the next slide. The differences between seat, place, and rules of arbitration. The suit itself is the legal jurisdiction that governs the arbitration and determines which court supervise the process. That is what the seat means. While the place means the physical location or the venue where the hearing occur and does not affect the governing law. So if arbitration does not affect the governing law, it is actually legal. So arbitration rule, which is the last, serves as the procedural framework for conducting the proceedings, including the arbitrator appointment and the evidence submission. So moving to the next slide, I'm speaking on the challenging an arbitral award. An arbitral award can be challenged based on specific legal or procedural flaws. So I won't be just listing there, I'll just explain what this slide is just talking about. So this includes where there's an invalid arbitration agreement, where there's an invalid arbitration agreement, where there's a lack of fair notice, that is the tribunal exceeding its authority, improper tribunal, and composition of or serious issues like fraud and then arbitrator misconduct. So when they are all these things that are listed here can challenge an arbitral award, can challenge an arbitral award. So I'll be moving to the next slide and the enforceability of arbitral awards. So arbitral awards are legally enforceable through courts if a party refuses to comply. So when an arbitration takes place and then a party does not comply or does not agree to what have been given, as the decision given at the end of every issue of the matter, then the party can now move to court. So the awards are legally enforceable. That meaning that the arbitral awards are enforceable through court if a party refuses to comply. So in Nigeria, enforcement requires providing the original award, the arbitration agreement, and proof that the decision is final and binding. So I'll be moving to a conclusion because our slide is very short. Here in conclusion, arbitration is, I'll just say it's a reliable and efficient alternative to litigation that provides speed, provides confidentiality, it provides flexibility, and then
Hello,
it's
sorry,
supported.
sorry, sorry to come in here. Can you explain the slides before this one again?
Which one, sir?
The one, yes, this one before the
This
next
one?
one. Yeah. Can you go over again?
Okay. So here, well, one of the major advantages of arbitration is that arbitral awards are legally enforceable if a party refuses to comply with the award, meaning that arbitral awards are enforceable in court. So in Nigeria, enforcement of arbitral awards is governed by the Arbitration and Mediation Act of the 2023. So to enforce an arbitral award, the application must provide you must provide the original arbitral award or the certified copy. So during the arbitration, there is a decision that is being given at the end. So that decision given at the end is the original arbitral award or the certified copy. Then number two is the arbitration agreement, and then the evidence that the award is final and binding. If you can remember at the beginning, I said that it has to be written, and the writing must be in English. So that's number three, meaning the evidence that the award is final and binding, meaning that arbitration itself is how will I put it, is enforceable through court if a party refuses to comply. So um, in Nigeria, enforcement requires providing requirements. So these are the requirements: the original arbitral award or a certified copy, the arbitration agreement, and then the evidence that the award is final and binding. Are you okay with it, sir? Should I move to the next slide?
Yes, please move on. Yes, please move on. Thank you.
Thank you, sir. So in conclusion, as I was saying, I said arbitration is something that is an alternative to litigation. It provides a strict confidentiality. Arbitration is flexible, as we were told, it supports a modern framework like the Arbitration and Mediation Act of 2023. So ensures that decisions are internationally enforceable. So in arbitration, what we need to understand is that there is speech, there is confidentiality, there's flexibility, and then there is international enforceability of decision. So that's all from me, sir. Thank you.
All right. Thank you so much, Mr. Joseph, for helping us run through your presentation. Well done once again to you and to your team for putting it together and for also sharing your slides. So thank you so much, Mr. Joseph. All
Thank
right,
you very much.
so I think we're done with the presentation from the mentees. We'll be going over to the mentors to hear them share their thoughts on your presentation and also run us through the class for today, letting us know we're discussing arbitration and the career opportunities in arbitration. Mr. Nyacham, I don't know if you're with us, and if you're with us, we would want to hand over the session to you for the mentees, for the mentors rather, their discussion. Okay, I just forgot, right? Just before we do that, that's before our mentors come on board. Please, can you quickly take our pictures? I know that in some of our locations is already getting dark, so let's quickly do that before our mentors come on board. So please, if you are in a position to turn on your video, kindly do that. Let's quickly take pictures. Thank you so much, Mr. Joseph. Can we have more mentees turn on their videos, please? We'd like to have all of us respond. It is important for us to get to identify that we were in session so that, yeah, thank you. Thank you so much, Mr. Isaac. Do we have more mentees? Please, mentees, turn on your videos. Let's quickly take our pictures. Thank you so much, Mr. Archie. All right. So Mr. Nyacham, over to you, sir. We would like for you to help us coordinate the session from the mentors. You're welcome.
Okay, thank you very much. Um, Thank you to all the presenters. You have done wonderfully well. Um, so the presentation was so wonderfully made, such that I just enjoyed listening. You know. So, Mr. President, thank you so much for being available. I appreciate your presence. Group one and two presenters, thank you so much for making time and working. Thank you, Mr. Chia. I can see you here. So I think I will give Mr. I will give Mr. Um, Achi. Mr. Achi, can you hear me? Hello? Can you hear me, Mr. Achi?
Okay, yeah, my network is breaking, so, but I don't know. Can you hear me too, sir?
Yes, I can hear you. So I will give you time to say what you want to say. After which, Mr. President, Mr. Isaac,
Okay.
sorry, Mr. Isaac, please, after which you will now give us a constructive feedback as to what the presenters have done. Then we will entertain questions. Please, you can drop questions on the chat box as well. Thank you.
Okay. So thank you very much for this privilege to rub minds with the information that were presented. I did enjoy it myself, truly. It's always an interactive and improving moment to listen to the mentees make their presentations. Of course, as we are progressing across the spectrum in ADR, the thing is becoming more interesting and it's becoming more legal too. So I did enjoy myself being from the academia. So the input I will make, I will start with the presentation of the slides, particularly group 2. Your slides, the content was not is very blurry. I don't know if I was the only one seeing that. So maybe in your next presentation, you may decide to have more slides and then lesser words. The words will come, they are so loaded. In every slide is so loaded. So the informations were not very clearly. One cannot quickly grab what is therein. We can decide to use infographics in our presentations, other than just wording. That will help to catch the attention of those that are listening. So that's one hand, the technicality of the presentation. And then the other thing I want to also say is that since we are looking at career prospects, I would want to encourage that the mentee should, I think by now, we have been able to locate some firm or organizations that need volunteer services. Is one of the things I encourage earlier careers to get into. So be it mediation, be it arbitration, and the other spectrum in the ADR, I encourage that let's try to offer our services even for free. In doing that, we are able to build experience, and then we will become indispensable. So that's one of the things I want to encourage. Let's get into volunteer services. There are a lot of organizations out there. And that, again, is something you can combine with your studies for those of you that are still in school. So I think that's what I want to add up to as part of my input. If I can remember any other thing, I will come up later. Thank you very much for the opportunity.
Hello, Mr. Nacha, are you with us, sir? Can we hear me? Can you hear me?
Yes, I can hear Mr. Nanchang. I think I'm through. The next mentor can come up. I think he did mention Mr. Isaac can come up thereafter.
Yes. Okay. So, Mr. Isaac, we'll be taking feedback from you, sir. If you're with us,
Okay,
we'd like to get your thoughts, sir.
thank you. I'm here. Okay, thank you. Good evening, everyone. It's been a pleasure to always listen to the mentees. Let me say that it's been an insightful presentation, especially with the group that presented first. I think your presentation was really loaded with a lot of information. Maybe next time you may try to reduce some of the text so that you can explaining with more flesh to it. So I think you did a lot of research, which was really thorough, and let me appreciate the effort. With group two, that is why I paused you at a certain point where I realized that your slides was a little bit scanty, and you were giving the explanation which was not in correspondence with the slide that I was seeing. That is why I paused you to go over so that by the upon explanation I got what you were trying to put across. So it is good that we are doing this, and it is important that we become as clear as we want people to understand. Remember that alternative dispute resolution mechanisms are meant to ease pressure on parties. So uh, we are not in to deal with a lot of legal jargons and things, but to make it as simple as an individual on the streets, anyone who can understand arbitration will know. So the presentation today is good, and group one, I think group two, you were looking at enforcement. Correct me, were you supposed to also add the agreement, arbitration agreement? Was it also part of your work? Group two, correct me. Let me know. Is the group that presented second, were you supposed to look at the arbitration agreement as well?
Sorry, sir, I didn't get you. Yeah.
Yes, Joseph, come again.
I didn't get you, sir.
Yes, I was asking whether you were supposed to look at both the arbitration agreement and the enforcement of the award. Is it the one that you were supposed to look at, or you were supposed to look at the enforcement aspect only?
That's the enforcement, sir.
Enforcement, okay, that's fine. All right, so thank you. I think the group one, your presentation was, I think you should have shown some examples of the arbitration award. Although you did mention some of them, should have shown example of them, and also the group two. You were talking about enforcement processes where you made mention of the particular sections and the law. I would have wished that you made provisions of those laws in the slide so that it is easy for somebody to make reference to that. So when it comes to arbitration, one thing that has to come in mind when everyone starts listening to you is that arbitration is like a court in a private setting, a court where parties are able to choose their own judges, a court where parties are able to choose their own procedure, a court where parties are able to design the duration of their process, because that is where parties decide that, okay, because of our business, we don't want to sit on this matter for long, and we expect the arbitrators to conclude the arbitration within 6 months, within 3 months. But the court, you can't decide for the court like that. But this is a private court. So arbitration is like a private, as a court, which is in a private setting. So looking at the futures. So the need for you to understand certain futures of arbitration. One of them is party autonomy. So arbitration thrives, as we have said about characteristics of ADR. So arbitration also thrives on parties autonomy, and arbitration must also thrive on consensual agreement. So the agreement can be a prior agreement within a contract. So now a lot of institutions have made provision for even agreement which does not exist. So when parties do not have an agreement to go for an arbitration, in the event of a dispute, they can still write another agreement. So in arbitration, if you are talking about arbitration, we should understand that people can go to arbitration with an agreement which is in a pre-existing contract or a prior agreement that the parties have made, or two, the parties could have done as what we call a submission agreement. That is what we call afterthought. So after the dispute has occurred, parties decide to now sign what we call submission agreement to go for arbitration. So these are things that you need to understand and appreciate. So you know that arbitration can also be an institutional. We can have an institutional arbitration, or we can have an ad hoc arbitration. When we are talking about ad hoc, parties do not choose a particular institution or a particular arbitrator, but they choose that in the event of a dispute, we are going to use arbitration. We are going to choose this rule. We are going to choose that person. We are going to choose this. So they do not select a particular institution to submit their matter to, such as Shati, that maybe in the event of a dispute, we will submit the arbitration under the rules of Shati. If you mention that, then it means that the nature of the arbitration has changed into an institutional arbitration. So there are a couple of institutions, Shati, ICC, AFCOT, several institutions that are there that offer such services to the people. Then the group one mentioned about UNCITRAL. UNCITRAL, which is the United Nation Convention on or Commission on Trade Law. So the United Nations has a commission that works on international trade laws and how international trade issues when it comes to trade policies and guidelines, not only on conflict resolution or only on arbitration or mediation, but because of the way they are doing trade laws and other, they recognize the need for people to be able to resolve their issues cross border around people, nations, individuals trading among themselves should be able to resolve their issue. That is why the UNCITRAL, seeing the need for a guide for people to also use, they brought the UNCITRAL model law. So you were trying to pronounce the name. That's why you said the UNCRAS. That is called UNCITRAL. The UNCITRAL model law, which was started around the 1970, and they keep on refining the law. And they have UNCITRAL rules. So there are two kinds when it comes to the UNCITRAL. There is a UNCITRAL model law, which is just a guide for countries that want to draft a new mediation or arbitration law, to look at the way the UNCITRAL laws are and also learn from it to draft their own. Then we have the UNCITRAL model, UNCITRAL rules. The rules are um, ad hoc rules which has been made by the UNCITRAL, so that parties who do not want to rely on a particular institution to resolve their issues can use those rules to guide the initiation of the arbitration and the arbitration process, so that they can have their matter resolved. You made mention of the UNCITRAL. That is why I am laying emphasis on the UNCITRAL, so that you get the basic understanding of what the UNCITRAL stands for and what they do, and also what they are doing in mediation and arbitration. It is through the UNCITRAL that we're able to get the the New York Convention, which is the recognition and enforcement of foreign arbitral awards, which Nigeria is also a signatory and also has rectified them. And if you look at Africa, for instance, Nigeria, when they talk about mediation, the Singapore Convention on Mediation, it was also UNCITRAL which did it. So it also passed in 2018. The arbitration, that the New York Convention was done in 1958. The Singapore Mediation Convention is 2018. That one in Africa, when it comes to Africa, the only country that has rectified that particular act is Nigeria, which was in November 2023. So only Nigeria has rectified fully that particular convention. So these are some of the things that as learners you have to know. And also touching on the careers, yes, you did so well in bringing out, teasing out a lot of careers that individuals can access within the practice of arbitration. Arbitration doesn't happen in a vacuum. The same way a court setting is, you have a registrar, you have clerks. The same way when it comes to arbitration, you may have, when it comes to institution, there is a registrar at the institution that you go and file your arbitral issue. There are administrators that can help the tribunals or administrative secretaries. So these are good researches that you have done, and you have compiled them and bringing them out so that learners can see that in going in arbitration, it is not only about serving as arbitrator, but you can be a case manager for an arbitration center, you can be an administrator for a tribunal, you can be a secretary for a tribunal. And this is good for you to understand and for you to work towards it. Through that, you can also practice and become well known within the industry. So this is where I'll pause for now and wish you the very best. And I want to say that keep it up as you come into the ADR practice. The field is wide. Begin to talk about it. Begin to share your opinion. Begin to attend. There are organizations such as WIPO, World International International Organization on IPs. So you can start following them. They do a lot of free trainings and webinars. There are a lot of organizations that offer such activities. You can also, if your finances are good, you can go for paid trainings where you begin to practice and begin to also get to know individuals within the sector. So on that note, thank you, and I wish you the very best.
Sorry, hello, Mr. Are you still with us, sir? Okay, I noticed Mr. Nacham is okay. I don't know if it's not available at the moment, but I see we have one of our other mentors who just joined in not too long ago. That's me. When you come on board. But I don't know, we would just like to also hear from you, share your thoughts on our topic for today, that is arbitration and the career opportunities in arbitration. You're welcome, Ms. Jennifer.
Okay, so do we have questions from the mentees? Do we have questions from the mentees?
Hello, Mr. Nacham, can you hear us? Or can you hear me?
I said, do we have questions from the mentees?
Oh, okay. Mrs. Music, we have questions. Let's go ahead and ask.
We don't have any
So, sir,
questions.
there's a question on the chat box, sir. There's a question from Buluwatife. She's asking, in case of a bias arbitrator or where the law was not followed in the process of an arbitration, can the award be revoked or declared unenforceable?
Okay, Mr. Isaac, please attend to your question.
Hello, Mr. Isaac. Are you with us, sir? Mr. Nwacham asked
Can you ask the
the
question
case of
again? Sorry, I
opportunity.
didn't hear the question.
All right, the question is in case of
So,
a
Mr.
biased
Isaac,
arbitrator
Jennifer is
or
around
where
to
the
give us her thoughts.
I'm saying that, can you ask the question again? I didn't hear the question.
oh,
Hello, can you hear me?
all right, Mr. Isaac, yes, sir, we can hear you. We'll get back to the question. Mr. Nwacham wants us to take feedback or contributions from Miss Jennifer first.
Okay, all right.
Yes. All right, thank you, sir. Ms. Jennifer, if you're with us, please, we'd like arbitration and then career opportunities in arbitration. If you're with us now, we'd like to get your thoughts.
Good evening, everybody.
Yes, good
Can you hear
evening, Ma.
everyone?
We can hear you loud and clear.
Yes, so thank you for this opportunity. I listened keenly to the um the corrections that were made by our keynote speaker for tonight and all. So, and he said one thing that hit very well, that there are so many areas that one can explore in arbitration. So, and I just want to chip that in. Aside from the areas you can function as an arbitrator, which they outlined in their um, assignments, I think there are also other areas of specialization, just like litigation. You can specialize in arbitration too, because even when I got into arbitration, when I went through the class and all, I realized that a lot of marriage matters, like divorce matters, kept coming to me. And I was like, probably I'm meant to specialize in this area. So just like in litigation, you can do corporate law, oil and gas, family matters, and all. You can also specialize. You can specialize in arbitration as well. It is not just limited to representing corporate bodies and all. You can also say, okay, since I'm a family lawyer, I can inculcate arbitration into divorce matters. Rather than running to court, I can look for how I will settle them through arbitration. You can do so much, just the way there are areas of specialization in litigation. There are also wide areas of specialization in arbitration. So that's what I want to contribute tonight. So there's so much you can do in arbitration. Thank you.
All right, thank you so much, Ms. Jennifer, for your contributions. We really do appreciate your feedback, and we want to say thank you for being a part of the class. So moving forward, yes, we'll be going back to the question and answer segment. I hope we can all hear me clearly. Please, can you confirm that you can hear me clearly?
Yes, I can hear you, sir.
All right. I think, Mr. Isaac, if you said something, I'm not sure I heard you clearly. Okay, so going back to the question is from Buluwatife, and she's asking, in the case of a biased arbitrator, where the law was not followed in the process of an arbitration, can the award be revoked or declared unenforceable by the courts? Did you get the question, sir?
Yes, I heard a question. Yes, that is a good question. In arbitration, you come to see a process where we call a challenge of award. So one of the ways that parties can challenge an award or set aside an award is through the one of the issues that she has mentioned, that when the arbitrator is biased, when the arbitrator does not follow a laid down procedural rules. So what are the rules that the people are supposed to follow? For instance, if you look at the UNCITRAL rule, it gives parties 30 days for them to reply to an arbitration. When you have sent them a notice of arbitration, they have within 30 days to reply. So if they have within 30 days to reply, and you as an arbitrator, the 30 days does not elapse, and you go ahead and give certain ruling, the parties can take you on and challenge that particular arbitration. The other issue has to also do with when the arbitrator does not respect the natural justice rule, where the other party, whether which party have not been given enough opportunity or were not given opportunity to also share their side of the issue or represent themselves well. But let me also emphasize that in arbitration, don't always look out for uh, an area or a loophole to go and challenge the award because it may go against you, because some of the rules are also strict on, if you have been given that opportunity and you don't take it and that opportunity elapses, you can go back and complain again, because some of the rules will specify that within this number of days, if you don't choose your side of the arbitrator, then the tribunal can go ahead and work and deliver the outcome. So these are some of the things that makes also arbitration likable, because you can't just play with the arbitration processes. It's like the court. If after filing and you don't do certain things, somebody can go for default judgment. In arbitration, it can happen as well. When can you hear me? My network blink a little bit. Can you hear me?
Yes, sir, we can
Yes,
hear
we
you,
can. I can
sir.
hear you.
Sorry, my network to do
Yes,
shaking.
thank you.
We can hear you.
So, okay, thank you. So these are some of the areas that arbitration award can be set aside. If you don't follow the natural justice rule, you arbitrate on matters that are not part of the scope of arbitration. So depending on the arbitral agreement or the arbitration agreement in the contract, if the arbitration agreement in this contract specify areas that can go for arbitration and go beyond that, that award can be set aside. If the arbitrator is also biased, the award can be set aside if you are able to prove that indeed the arbitrator acted in bad faith, and that matter the arbitrator was biased through the process, the award will be set aside. And when it comes to foreign award being enforced in another country, one, it must also have reciprocal agreement with the other country, and also the award should not be pending an appeal. There shouldn't be any appeal on that particular award or legal challenge in the country that you are bringing it from. So the where the award is emanating from, there is no pending a pending issue against it, right? So I hope I've answered your question. Thank you.
Yes, sir.
Isaac for
Thank you,
helping us
sir.
run through. Thank you so much, Mr. Isaac, for helping us run through that question. We have a question from Peace Chinenye. Peace is asking, what is the most common ethical mistakes arbitrators make, and how can a young lawyer avoid?
Oh, what is
Can you
this?
confirm if you can hear me?
We can hear you now, sir. My network is a bit shaky, so I'm not really getting you, but I can hear you.
Okay, please, can you all confirm if you can hear me?
Yes, Nanchan, I can hear you.
Okay, so uh, thank you, Mr. Isaac, for giving us an insight and answering that question for us. Um, the second question as to what are the most common ethical mistakes arbitrators make, and how can a young lawyer avoid them? Well, let me start by saying that um, when you talk about young lawyers, are you referring to young lawyers that are defending arbitration proceedings, or young lawyers in which sense? Is it young lawyers that are appointed as arbitrators? So I don't know if you can clarify the question, please. Please, can you clarify the question you asked?
Okay, please wrote a response. He said, sorry, sir, not young lawyers. I mean, people who want to delve into arbitration.
Okay. Let me start by saying that as a young lawyer, one of the things that you need to do, uh, if you want to dive into arbitration, you should first understand what area of arbitration you want to go into. Now, like Jennifer has said, under the law, we have different types of specializations. You can go into construction, you can go into oil and gas, you can go into family, among several other things. So if you are a young lawyer and you want to specialize, you will start first by defining where you want to specialize in. So if you, let's say for example, you are a specialist in admiral uh, laws or international law and diplomacy, you know, these are the things that you begin to look at. We are looking at subject matter expertise, and one of the I think the presenters have made us understand that among the career opportunities, you can be an expert witness. So when there is an oil and gas dispute, for example, and you need an expert who is conversant with the oil and gas area to settle, You'll be looking for an expert who is not just an expert in oil and gas, but someone also who is familiar with the ADR or the ADR processes. So if you're able to define which area you want to specialize in, that's one important thing and decision you have arrived at. Then uh, once you have decided where the area you want to, one of the mentors, Mr. Achis, has mentioned that you should try and develop, avail yourself for, uh, you should try and develop yourself or avail yourself for uh, a kind of, you should develop yourself in a kind of um, volunteer activity. So when we talk about volunteer activities, we are talking about look for organizations, law firms. Please can you confirm if you can hear me?
Yes, sir, we can hear
Hello?
you.
Yes, we can
Yes,
hear
sir, we
you.
can hear
Yes,
you.
Barrister.
yes, sir, we can hear you. Yes, sir.
Yes. So you look for organizations that specialize in that kind of area. So if you so uh, if you get an ADR organization or an organization that is into uh, conflict resolution, you volunteer. When you volunteer, you'll be able to see in practical sense how issues are being resolved. Uh, you'll be able to see in practical sense how issues and matters are being resolved. So you develop yourself to that point to be able to have practical experience. Now you see, just like lawyers, I know some of us are lawyers here. One of the things that we do is that the moment you graduate from school and you become a lawyer, one of your goal will be that I've spent 6 years or 7 years pursuing a law degree, so it is time for me to make money, right? So it's time for me to make money. So you see that instead of concentrating to learn how to do the work, because you are going to survive, especially in the ADR space, based on your ability to do the work well when you have it. And nobody will commit a very important work to you when they have not been able to attest to your ability to um, a kind of attest your ability to handle the matter effectively, professionally, and experience-wise. So that's why you see most times when you see organization looking for employment opportunity or looking for people who will work for them, one of the things that they do is they will tell you that they are looking for someone. This one that I'm not seeing anybody's face. I don't know whether I'm just talking to myself. If you can put on your camera, please, I would really appreciate it. Those
Barrister, we
that,
are following. We are listening.
those that can put on your camera, let me see your beautiful faces. All right, so you see, when you see employers looking for employment, they will tell you that, especially even in the law sphere, law firms, other organizations, they will tell you that they are looking for someone with 2 years experience. They are looking for somebody with 2 years experience. someone who can function with minimal supervision. So what are they trying to tell you that? What are they trying to tell you? They are trying to tell you that they are looking for somebody who can on his own function, who has gathered experience and knowledge, although it's not everybody that is ready to avail you that opportunity to learn and take the pain of teaching you so that you can gather the experience. But when people are looking for those they will employ for the purpose of paying, they are looking for people who have already they have that experience. So that's one thing. That's another thing. That's the one important thing you need to look out for. So that's why, as Mr. Achi has mentioned, you look out for opportunities to volunteer. When you volunteer, ordinarily you hardly be rejected. Although it's not everywhere you'll be accepted, but you hardly be rejected. The idea is that okay, this person is willing to come and serve or work or do things for us for free. He wants to use the opportunity to learn. So you see that you have access to top secrets, top information, experiences, knowledge sharing sessions, meetings, that ordinarily, if you are an employee, it will take you like 10 years before, or 10 or 15 years before you can get to that level where they will allow you to be able to go into such meetings. So volunteering gives you the opportunity that ordinary employment will not be able to. So if you're employed as a junior staff, your work is to concentrate to do your work as a junior staff. And there will be nothing like saying, okay, the management are going for meetings and, so you follow up. Nothing like that. You will you are looking for opportunities to see how you can take part in practical experience, take part in practical sessions where they are doing arbitration, where you are assisting as a secretary or an arbitral registrar, where you are involved in drafting some of the processes that are going to be used in the arbitration processes, where you will be saying, oh, they are drafting a procedural order, so you take part, you say, oh yeah, draft the headings, draft this and this, bring the learning see. Oh, you did well. Oh, this is how you are supposed to do it. This is how you are supposed to do it. Oh, you shouldn't have done it like this. You should have done it this way. You know, those are some of the things that you do. So if you want to avoid mistakes, you want to avoid some of the things that we're talking about, one of the things is that you must put the first 3, 4, 5 years of your practice, you must dedicate it to learning and developing competence and expertise, not going after money. You see, the unfortunate thing is that those who are looking for money, they are running after money. Money is running away from them. But those who dedicate their time to be able to learn, those who dedicate their time to be able to learn what they need to do, they develop the expertise, and it is in those times, in those periods where you will now have opportunity to expose yourself. I don't know if you can hear me.
Yes, sir, I
Hello?
can hear you.
Yes, you're audible. You're audible.
Yeah, so you see, when you are chasing
I
after
can hear.
money, yes, when you are looking for money instead of developing your competence and your capability, you will see that when someone asks you to do something, you are asking for money. How much will you pay me? The person, if the person is pressed, the person will say, oh, okay, how much do you want me to pay you? Pay me so amount of money. And then you will feel that it's because you are a lawyer or because you are an ADR practitioner or you are this and that, that's why they gave you that opportunity. After you finish doing that and he pays you that stipends or what he gave you, you may not see him again. He may not engage you again because you have shown him that you are not interested in developing any relationship. You are not interested in developing your professional capacity. You are interested in money. It is only when he needs you to do something and is ready to pay you that he may engage your services. But on the other hand, if you make somebody understand that you are very much interested in these things and you say, okay, come, help me go through this process, help me draft this, help me do that. That is what a beginner should be able to should be looking for. Should be looking for that opportunity. Because by the time you walk along, when you work with people who are experienced in that field, you see that by the time you have opportunity to do these things by yourself, you will do it so well because you are already conversant with the process. And with that, you will see that you are going to avoid several other mistakes that people who do not have opportunity to do a kind of tutelage will get. So you see, that is why I think that recently the Nigerian Bar Association has brought out a circular to say that every lawyer who graduated, when you become a lawyer, you must do a compulsory tutelage for some years, maybe 2 years or thereabout. You must do a compulsory tutelage so that you'll be able to learn the rudiment. Because most times, some of the things you are learning in theory, it may be different from the practice, or you must learn how to convert your knowledge, that the knowledge that you have gathered, into practice. So I don't know if I've attempted your question anyway. Hello? Can you all hear me? Hello?
Yes, barista. I can hear you.
We can hear you, sir.
Okay. So I think that's the question that we have, right? On the platform.
Yes, sir. That's all the questions we
Okay,
have, sir.
so now, finally, just trying to tie these things together. Let me see what time. Okay, let me take some minutes to tie it up. So you see, you are going to be doing a practical in arbitration, and I saw that you have presented things wonderfully well. You have researched well, just like other mentors have stated. That is wonderful. That is good. But one thing you need to bear in mind is the processes and the stages of this arbitration. First of all, where do you start from? So before you can commence an arbitration, you must first understand that there must be an agreement to arbitrate. That agreement is either found in your either contract, your agreement, or when a dispute arises, you can now prepare. When a dispute arises, you can now come together and then do a separate arbitration agreement for that purpose. We always advise that it is better to agree as to how to go about resolving your disputes when there is peace, when you are all together, you are trying to find a way of starting your business. Include those dispute resolution clauses there. It is very, very important. You need to include the dispute resolution clause because you agree. If there is a dispute, we'll go for negotiation. After negotiation, we'll go for mediation. After mediation, we'll go for uh, arbitration. Now, those of you who are doing, who make presentations, you don't wonderfully well. When you are talking of ADR organization, ADR institution, arbitration institutions, You have not mentioned Settlement House Area Training Institute. So I'm going to score you 0, for that purpose, because Settlement House is the one making sure that this training comes to you. And when you are doing your research and you are doing whatsoever, you forget the fact that the people who are bringing the opportunity to you, they are area organizations. So it is an area training institute. So they train and certify mediators, arbitrators, negotiators. They also have a panel of neutrals of those who can be appointed to resolve disputes. So when you are doing something like this, you look out for the organization that is empowering you. They should be first among your list of arbitral or institutions. That's on a lighter note, but always take note of it. Always promote the interest of the person who is trying to promote your interest. That's a very good thing to do. So when you have an arbitration clause or arbitration agreement, which the law, the Arbitration and Mediation Act, has clearly stated that that agreement now can be in, once it is in a form of writing, whether it is writing in a book like this one, whether it is in a writing in a book like this one, or it is in a text message, or it is in a telegram, or it is in an email, as long as you have agreed that when your dispute arises, you are going to resolve it through arbitration, that settles it. It may not be formal in the form of document, or it can be made reference to in another body of agreements, and all of those things. So that is where to start from. Once there is a dispute resolution clause and it includes arbitration, it means that even if the matter goes to court, the law clearly says that that matter can be stayed and they will send you back to arbitration. I know once you go for arbitration, whether you like it or not, you must resolve, because it is the arbitrator that gives decision, and that decision is binding on you. So that is what happens. So once you have your arbitration agreement, which I said there are 2 ways you may have it, either before the dispute arises or after the dispute arises. It may be contained in your contract or in your agreement. That is the first place to. Now, when the dispute arises, so when the dispute arises, the first thing you will do is that you must commence the arbitration. And by commencing the arbitration, you must issue notice of arbitration. Now, if I am party A and I'm the one aggrieved, it means that I will be the one to initiate the process. When is arbitration commenced? When the other party has received notice of arbitration. And your notice of arbitration ordinarily to carry a reference to the agreement that you have, the part that has been breached by the other party, and you make mention of proposed arbitrators that you intend to appoint. By the way, I'm going into all these things. This is not an arbitration training or certification, but it is for your interest. It baffles me that some of you are coming to get free information, free training, when we sacrifice our time, but some of you are not here. That's the thing. So, but that notwithstanding, when you now have your when you are issuing the notice of arbitration, you take note of the agreement, that agreement, as arbitration agreement that has been breached. You mention it, the aspect that has been breached, and that you want to commence the arbitration, and you are proposing so and so Mr. Nanchang of N Nanchang and Co as the proposed arbitrator. This is his qualification and this and that. We are expecting that you are going to give us a response within 7 days or within 2 weeks of the receipt of this thing. So when you are issuing the notice of arbitration, you must ensure that the other party receives it and there is evidence that it is written. I'm telling you because you need to do an arbitration simulation, practicals. So once the notice of arbitration is issued according to the law, that is the commencement of the arbitration. Now the person who received the notice of arbitration may decide to respond and say, oh, In respect of this, and I've agreed with you. Let us go, since the law, our agreement say we should go for arbitration, and you look at, have we explore every other, according to lawyers, condition precedent? Have you established every other condition precedent that is necessary for the commencement of the action? You check. Was there an agreement that before you go for arbitration, you must explore negotiation? And if negotiation fails, you go for mediation. And if mediation fails, you go for arbitration. You cannot jump the process, the first two, and just go to arbitration because you say, I just want to dispense it quickly. You are going to go back again. So you take note of it. The person that received the notice of arbitration can respond to say, yes, I agree with you. No, I did not agree with you with the appointment. I'm proposing a different arbitrator for this and this and this reason. Now, where the person did not respond, he did not do anything, then you that issued the notice of arbitration can now go ahead and notify. You can notify the person you propose in the notice of arbitration as the arbitrator. You notify the person, and after you notify the person will have to first accept, declare that he does not have any interest in the matter, declare that he's going to be impartial, he does not have any relationship with the parties, and is accepting it, the appointment, and then he is going to now call, is going to issue notices to the both sides and then call for the first preliminary meeting. And at that first preliminary meeting, when he's coming, he's going to come also along with a proposal for a secretary or an arbitral registrar, depending on the nature of the arbitration. So that first meeting is very important because you are going to be having a conversation concerning important issues and matters that has to do with the arbitration. First, what is the language you are going to be using? Are you going to be needing interpreter? Where is going to be the seat of the arbitration? Where is going to be the venue, of the arbitration? I've not had some of you mention the issue of the seat and the venue. When they say seat, it does not mean seat that I'm sitting on like this. No, the seat of the arbitration usually is maybe the law that governs, possibly the law that governs the arbitration. When you are talking of the venue, you are talking of physical location. So the law that governs that thing means that anything, when there is any need for you to rush to the court, to apply the law, it is the law of the state that applies. So, but on the other hand, the venue is just a physical venue. So you can have seat of the arbitration in Kaduna State, but you are going to do the venue of the arbitration can be in London. The only disadvantage is that if you want to do something, either you fly from London to this place. So we're trying to make Nigeria a very good state. We are going to make our states, various states, Kaduna State, a good state, Abuja has been taking it, Lagos has been taking it because of the state, because of the law. They have been advanced and developed in arbitration laws. So once you have the arbitrator accept the appointment, he issues notices for the first preliminary meeting by the parties. The parties are supposed to appear and come before him. When they come before him, they discuss, okay, you have processes you need to file. You are going to file your point of claim. How many days do you need? You are going to file your point of defense. How many days do you need? Do you have a counter claim? How many days do you need? Do you need to respond to the counter claim? How many days do you need? You put all of these days together and say, okay, we are taking like 1 month or 2 months for parties to file everything they need to file. You are going to discuss about the register. The first thing the arbitrator does is to say, okay, upon my appointment, I feel that we need a registrar or a secretary, and I have got someone. This is his profile. This is his profile. This is his resume. This is his experience. I just want to hear whether you are going to confirm the person or not. When you confirm the person as a registrar, he starts his work immediately, and then he begins to take record of all the proceedings and the things that are happening. You are going to agree as to the arbitrator's fee, arbitration fee. You are going to agree on the fee for the arbitral secretary. And remember, All these things are going to be influenced, or they are going to be determined depending on whether they are institutional or ad hoc arbitration. When you talk about institutional arbitration, it's an arbitration that is conducted under an institute. For example, Settlement House Area Training Institute is an institution that administers arbitration, administers mediation and negotiation, among other things. So when you say your dispute, or it is the rules of Settlement House or Shaki that is going to be applicable to guide the arbitration, automatically you are saying that it has turned into institutional arbitration, like Mr. Isaac, my president, has said. So once it is institutional, institutions usually have their laws, they have their own rules and regulations, they have their own scale of charges, they have their own panel of neutrals, they have their own scale of charges, among several things, for registrars, for arbitrators, and the percentage that is supposed to come to the institute, and the things you need to do before you commence. So some people consider that institutional arbitration is expensive. So when they get an opportunity, or when a dispute arises and there is arbitration, they just approach an individual who they believe has the competence or the ability to resolve that issue, not necessarily under any institution. They just approach him and say, we are appointing you, or they will write to him that we have appointed you as an arbitrator. That type of arbitration means that you are doing an ad hoc arbitration. And if you are doing an ad hoc arbitration, it means that, if you are doing institutional, the arbitral institution, on its own, will sort out the issue of venue, the place for meeting, and all of those things will be sorted out by the institution. But when you are doing an ad hoc arbitration, it means you have to sort out those things by yourself. So at your preliminary meeting, you are going to be discussing, where is the venue for this? Where are we going to be lodging? Do we need to sit for the 1 till 1 week or 2 weeks consistently every day? Are we going to be taking breaks? What are the arrangements for transportation of arbitrators? Do we need accommodation? Do we need feeding? Do we need breakfast? And all of those things, you are going to be looking at them at the first preliminary meeting. So you are going to understand, you are going to agree as to what procedure, what rules are you going to adopt? What rule is going to guide the arbitration? You can adopt any one of them, whether it is NICA, whether it is SHATI, whether it is ICC, or whether it is Lagos Chamber of Commerce, whether it is Nigerian Chamber of Commerce, and all of those things. You decide the rules, you decide the language. You are going to decide whether you need an interpreter. You are going to find out whether you need an expert witness. All these things are going to be discussed at your preliminary meeting, including the fees, how the fees are supposed to be paid, the percentage that needs to be paid before, and all of those things. So that preliminary meeting is very important. So after you have done your preliminary meeting, what you need to do, you are going to give a summary of the meeting and then issue your procedure, what do they call it now? You issue your the order of direction, by the arbitrator. So that order of direction, they can call it any other name, but it's going to consist of the summary of all that you have discussed and the agreements that you have heard, you have made, and then the directive that the court has, I say the court now, I said the arbitrator has given. Okay, you need to pay the first installment within 2 weeks. You need to file your processes within 3 weeks. You need to respond to these processes within so time. And then after all these things is done, the arbitral secretary is going to confirm that these things have been done. If you leave me as a teacher, I will keep talking and talking and teaching, and then before you know it, the time has gone. But bear with me, let me just summarize. Once that is done and you issue that the order of direction, so to say, you issue, you give the summary of what has happened, and then the directive of the arbitrator as to what and what needs to be done. Some people after that decide to go straight into the arbitration and fix a date for hearing. Some people may decide to adjourn the matter for the second preliminary meeting, where you are going to come at that meeting to be able to confirm, okay, you were supposed to file your processes, your point of claim and point of defense and counterclaim within 1 month. Have you done so? Have you done this? Have you done that? You say, yes, we have done this, we have done that. You see, you are done with that aspect. Then you confirm, okay, you are supposed to make the first deposit and installment of so amount of money. Has that been done? Say yes. You are going to cross your T's and dot your I's. Okay, we are supposed to have a witness, we have interpreter and all of those things. Have you sorted all these things? Say yes, we have sorted it out. That's for the second preliminary meeting, if you want to go into that preliminary meeting. But you have instances where you have issued notice of arbitration, you have issued hearing notices to the parties for the first preliminary meeting and nobody showed up. You can use your discretion as an arbitrator and say, okay, let us give this person another opportunity. And by giving opportunity, you ask the registrar to ensure that you start against the next date for the hearing. And if the person is served against the next date, it's also your own discretion as an arbitrator to say, okay, since he did not come again, let's give him the third chance. Some arbitrators don't take any form of nonsense. So when they serve you and they sure they serve you, the first day they come, they will just proceed with what they want to do. But to be on the safer side, you can decide to follow peace with all men and give the person opportunity 2 or 3 times so that when you are closing that opportunity, you are closing it permanently. When somebody comes to review, lawyers using their evil eye to check, did you breach the principle of fair hearing? It is a constitutional matter, do this and that. When they are looking for opportunity to challenge your award, don't give them anyone. So give the person opportunity. So what I'm trying to say is that in arbitration, where you cannot force somebody to come, although when you have someone witnesses, you can go to court and get those things stamped. We have ADR judges and registry that are ADR compliant. You can get the summons stamped by a judge and compel someone to come and testify. But aside from that, you cannot force somebody to say he should come and testify or he should come and defend himself. What you owe that person, just like in court, is just to be issuing your directive, issuing the hearing notices, ensure that the person is served and there is evidence that he is served and he received it personally or in the address. Remember, in your preliminary meeting, one of the things you are going to be discussing is how parties are going to be served. The address, how the way and manner they need to be served. Is it by email only? Is it by physical deposit in their offices? Is it by text message? All these things should be agreed by all of them, so that by all means you ensure that everything is being sorted out. That is what you need to do. So once you're able to be done with your first preliminary meeting, and if you call for second, you are done with the second, you adjourn your matter for hearing. And when hearing, just like Mr. Isaac, my president, has said, when it comes to hearing usually is just the way the court is. It's just that you will not see people will weak and down, and then the strict rules application of the Evidence Act does not apply to arbitration. So, but the processes is the same. You have the registrar of court, the registrar of the arbitral tribunal. You can administer oath. The person will depose. Remember, you have filed your processes. You adopt it, and then when you adopt this party A is going to cross-examine your witness based on those things. Remember, at your preliminary meeting, you are going to decide the type of arbitration that you want. Is it an arbitration that you want to conduct based on documents only? Is it a type of arbitration that you're going to conduct maybe based on the mixture of documents and oral evidence? So when you decide that one, when it is documentary evidence that you are going to be using, you don't need anybody to come and be giving oral evidence or cross-examination. Documents, according to the law, they speak. Documents speak for themselves. I mean, so that is it. So once you decide, the hearing process is the same thing. You come, you call the witness, the lawyer who appears for the counsel in the arbitration introduces himself. I am so so so. But when you come to the arbitration table, what you do, you introduce yourself. You ask the parties how they will want to be addressed. So come and say, yes, my lord, yes, your lordship, and all of those things. The arbitrator may so just call me Mr. Arbitrator, or just call me Mr. Nanchan. I know that that's the arbitrator. Then party A and this, oh, I am N Nanchan, I'm appearing for the plaintiff or the complainant or the petitioner, whatever you want to call the person. So and my witness is here, or my client is there, or his representative of the company is here. This other person also introduces himself. He says, okay, our matter is there. Okay, we have filed our processes. This one, you do it on oath. You adopt the processes, and then party A cross-examines the party. After the cross-examination, it turns to party B. Party B also calls his witness. He adopts his point of defense, and then he's cross-examined. After the cross-examination, the next stage you are going to do is that you have time for you to file either your written addresses, so you may have written addresses. If you agree that you're going to be having a written address in your first plenary meeting, you are going to file your written addresses. So when you file your written address, you can decide that you're going to have oral time for adumberation to explain, or you have 5 minutes, 10 minutes, 20 minutes to be able to adumbrate or do oral submission, depending on the type you have agreed upon. So after you have done that, you done your cross-examination, you close, you summarize the case, written addresses, oral submission usually is simple. There are issues or things that you want to draw the attention of the court based on the evidence you have presented before them. So when you feel that, okay, I've established this from my document, you find the law or the case law that marries that thing together, and you say, okay, in so case and so case, this is what happened, and this and that, so you refer to relevant cases that apply to what you are saying, especially arbitration cases, related cases. So once that is done, you make your submission. That can be done in a day, or it can be adjourned, depending on what you have agreed in your preliminary meeting. Because your preliminary meeting is one of the important meetings that you're going to be having, because it determines and decides the cost of the arbitration. So once that is done, you conclude the arbitration process. It is now left for the arbitrator to go, depending on what you agreed, maybe 1 week, 2 weeks, 2 months, to be able to publish the award. When you talk about publishing the award, you can just send it to registrar. Registrar will send it across to the parties. You may not necessarily call the parties and come and see like a judgment of the court, where you begin to read out these things to the parties and say, this is the judgment, this is the award of the court, and all of those kind of things. So no, publishing, before they publish the award, they want to confirm whether all the pennies, all the monies that needs to be paid have been paid and everything is ready. Then they publish the award. Once they release, you publish it at the same time, send it to the same parties at the same time. You are done with your work. You collect your money and you pocket it, and that is all. The arbitral process that you need to know. I have to take time to explain to you the processes and the stages of the arbitration, so that you know. It will guide you when you are preparing against the arbitration session, maybe in the next 2 weeks or thereabout. So basically, that is the arbitration um, process and some of the things that you will need to do. Let me use this opportunity to say that for those of you who are faithful during this period to do the training, and you do it to the logical conclusion, your certificate in this GPC Shati mentorship will qualify you to be able to upgrade your training to a certified mediator, with Settlement as Media Training Institute, and you can don't join any of our training that is coming. Possibly they will give you a very special consideration or subsidy because you are actually mentored by us, and then your certificate is going to serve as your uh, green passport, to enter into that. We are going to also start our arbitration certification very soon. And that will also give you an opportunity to join and become trained and certified as an arbitrator. So basically, those are the things that you need to do. And then I just try to see how I can marry some of the wonderful things that we have done together so that you now understand the processes and the stages and what you need to do at each point in time, from commencement to, the initial processes, the main trial, and then the conclusion of it through the publishing of your awards. Thank you so much. Is that the question I'm seeing? After presentation award, what is the process of enforcement of award? Okay, so Mr. Isaac would attempt that. Mr. Isaac, after you deliver award, what is the process of enforcement? There will be no need for enforcement. Let me say that there will be no need for enforcement except if the party defaults. So if the arbitrator has said, what arbitrators do is that they will tell you that you need to pay this amount of money within 10 days. Failure to do so, there is interest, there is penalty, and all of those things. So you'll be compelled to do it. But if you don't do it as expected, so it is your problem because the interest will be adding and adding, and then they cannot take proper steps towards enforcement. When you want to enforce, you get the CTC of the document, take it to the court that has jurisdiction, the high court in the state where you want to enforce it, and then register it as the judgment of the court, and you are free to go and enforce. Mr. Isaac, will you want to lend your voice to this as we conclude the session? Mr. President, are you with us? Okay, so the person who asked that question, I believe that I have attempted the question. After award enforcement, enforcement will not arise until somebody defaults. And I know that they may not ordinarily want to default. So thank you very much for your time. Let me hand over this to Mr. Dennis. Please remember that you have a responsibility to share some of the things that you have learned, tag your mentors, tag the institutions, Gypsy, tag Shati, mention, say something, throw the thing all around so that people will get to know what we do, the contributions that we have made, so that they can prepare possibly to join the next one that is coming up either next year or so. But you can the thing you can contribute if you don't have is to do something that will add value to the institutions that have created time to do this for you. Thank you so much, Mr. Dennis.
All right. Thank you so much, Mr. Nacham, for helping us run through today's class. We sincerely appreciate your mentorship alongside the other mentors that were present in the session. Thank you so much, everyone. We sincerely do appreciate. We have come to the end of today's session. We really hope that for the mentee side of things, you were able to learn something, a thing or two, and we advise that you revisit the rebroadcast session. You can go to the YouTube link will be posted in your group. You can always revisit it to get clarity on some of the things that were said and shared during this session. Yes, please do not forget to fill in your attendance. Do not forget to share what you have learned. Do not forget to tag the mentors that were present. Do not forget to tag the institutions, Gypsy and Shati, right? In the next class, we'll be handling practicals. We'll be taking practicals in the next class. We'll start off with mediation simulations, and then we'll move to arbitration simulations. So please, for the mentees, the tags will be coming up very soon. Please pay attention to it. Make sure to work together with your team members so that we can have a full, smooth flowing session next week. Thank you everyone for your time. Thank you everyone for your presence. Good night everyone and enjoy the rest of your evening.
Thank you, sir.